Hi, everybody. This is really an event that I've been so looking forward to because it is unusual for us to do the two things that we're going to do right now. One is to actually watch a lawyer have a conversation with his client. This is unusual. We don't do that regularly. And the second thing is to actually have a deep discussion about the current issues facing the media and newspapers in particular when they have potential legal problems. We don't talk about that very much. So I'm really thrilled that we're doing this event. Let me introduce our speakers. They are David Shribman, who is an award-winning journalist. He is now the executive editor of the Pittsburgh Post-Gazette. He has many ties to Boston. He previously had many roles at the Boston Globe, and he won the Pulitzer Prize in 1995 for his coverage of many things political. Is that right? Is that a fair way to put it?
Fair.
And you probably have seen him on TV a lot because he is often on TV covering the American political scene. His column, My Point, I'm sure many of you have read because it's syndicated nationally. And he has a wonderful work called I Remember My Teacher, which is a tribute to the nation's great educators. And that's one reason why I think he even consented to do this, because he understands the value of education. There are many more things I can say about him, but I'm going to not do that so that he has more minutes in his talk. And his lawyer is Fritz Byers. Now, Fritz Byers is our graduate, and I don't think you've been back in a while.
Not in this capacity.
Not in this capacity. Well, it's great to have you back. And in solo practice now, he previously had many roles that prepared him for the work that he does. He was general counsel to Block Communications, which had been called Blade Communications, a multimedia communications company. And he does a lot of work on First Amendment, privacy, internet-related subjects. He teaches the subject of communications law. And so, Fritz, welcome back.
Thank you.
David, thanks for being here. And now I'm going to shut up.
All right.
For my part, this is the only way I could get into the Harvard Law School, so I'm delighted to be invited.
Dean Minow, thanks very much. David and I are delighted to be here. It's a privilege to spend this time with you, and we want to spend the next hour talking with all of you about issues that we work on together and separately every day of our lives. David has been a practicing journalist for all of his adult life, and I've been a First Amendment lawyer almost from the time I graduated from here in the early 1980s. And when we say talk with you, we mean that. We received from Dean Minow several questions that have been posed to us about how lawyers and journalists work together, how journalists balance the journalistic imperatives of informing the public of governmental events, particularly aspects of governmental wrongdoing that have been kept secret. What role does legal advice have in the consideration by journalists of what to publish and when? How do factors extrinsic to the legal system, such as national security concerns or journalistic ethics, bear on this decision making? And we'll try and touch on those as we go through, but we would very much love to have this be a dialogue. David and I have done this periodically over the years, and we find that it is by far the richest experience when it's interactive. So if anything we say strikes you as silly or ill-formed or ill-considered or intriguing, please feel free to ask, and I think we'll have a lot of fun doing this that way. Before we begin, I thought it might be worth just a few minutes talking about sort of the philosophical and doctrinal structure within which we do our work, sort of the history of considerations that are brought to bear on the legal rights and obligations of newspapers, and what remedies are available to people who think they've been wronged by media conduct. This is a centuries-old question, although it's taken on significant constitutional import over the last half century or so. So if you will bear with me, I'll try and do this quickly, but sort of give you a background that when we teach this together, it takes us about 6 weeks to get there before we start doing this, this sort of minstrel show that we do together. Journalism and the conflicts that it faces really exist at the center of what we at least currently define as civic society. Those who engage in the daily miracle of producing a newspaper are discharging societal functions that for centuries have been recognized as fundamental not only to civic society but also the development of people as responsible participants in society and also fully realized individuals. The individual values that are protected by the Free Speech Clause and the Free Press Clause are myriad and they are profound. Many great scholars, such as Professor Emerson and Professor Meiklejohn, have talked about this. You can go back in Western civilization as far as John Milton's First Amendment treatise, Areopagitica, to learn about the sense of self-fulfillment that expression brings. Perhaps the best saying of this is that of Ralph Waldo Emerson, if you excuse the then contemporary sexism of his quote. He said, "A man is half himself, the other half is his expression." So our society has long recognized that the act of expressing one's views and perceptions and opinions is instrumental to the development of fully realized human beings. Likewise, there are crucial societal functions served by speech and press. Milton again commented on these. They suffuse Mill's work on liberty, and no doubt you've encountered some of the really grand expressions of these values in the famous dissents of Brandeis and Holmes in the late teens and the early 20s of last century. All of these principles are well recognized, so it really isn't grandiose to say that the activity of expressing ourselves in print and orally, and the discharge by the media of the surrogacy function, doing for all of us what we would do as responsible citizens if we had the time and access, the checking function and making sure that our governmental institutions are acting properly. These are functions that lie at the core of what we now consider to be our democratic society. And they're crucial functions. It's a bit of a parlor game to identify where these kinds of principles clash with other rights, which is what we mean by the legal process of resolving disputes. So arrayed against the values I just identified are values of reputation. Now would be where we would have the obligatory quote from Othello about the value of one's reputation. Values of privacy, which have been front and center in American jurisprudence since Warren and Brandeis's great article in 1890. And then the ever-increasing question of whether the First Amendment insulates media organizations from neutral laws of general application that apply to all other institutions. This relates to the ability, say, to refuse to testify in front of a grand jury, a right that many think a journalist should have, but no other citizens have. The legal regime for resolving these kind of societal conflicts has been around forever. Early on, in the early part of the last millennia, society resolved these disputes very much on the side of reputation, particularly the reputation of the church and the state. And Blackstone, in his famous formulation about the nature of free press, wrote in the mid-1700s that the liberty of the press, properly understood, represents only a freedom from prior restraints. And if one publishes inappropriate material, one bears the consequences of that. That's a concept that we would have trouble understanding now. But it's important to realize that well into the centuries of evolution of Anglo-American law, there were essentially no constitutional or policy restraints on the ideas of privacy and reputation and the other personal interests that are protected by tort law. That changed with the constitutionalization of tort law, of press rights. The first time the United States Supreme Court really paid any attention to this was in Neer versus Minnesota, when it constitutionalized the idea that prior restraints are unconstitutional. And then in what is, by my narrow view, one of the 2 or 3 most important decisions the Supreme Court has ever handed down, New York Times versus Sullivan, which utterly revolutionized the law of publications by suggesting that the First Amendment had altered American common law and the rights of individuals to seek redress when they thought their reputations had been damaged. These ideas have been clashing for 50 years, but it's remarkable to note that the doctrinal revolutions of the Warren Court, particularly those reflected in New York Times versus Sullivan, have been remarkably durable when measured against most of the other things that the Warren Court did, many of which have gone into the wastebasket of history. But even today, the central ideas of New York Times versus Sullivan and the related cases remain, for the most part, undiminished. But these principles are under tremendous pressure now. They're under economic pressure because of the changing marketplace of newspapers. They're under technological pressure because the idea of who can be a publisher and how we receive information about our government, how we express our views of government, is fundamentally altered by the technologies and the pervasiveness of the internet. They're also under tremendous pressure from geopolitical changes. The spidery intrusions of the national security state present remarkably delicate new challenges for journalists that are brought to the fore in the Snowden case and private Manning and many other things that I assume are of great importance to you as you speculate here about the world we would like to make. And then finally, these legal doctrines are under pressure by the work of innovative plaintiffs' lawyers who are trying to develop new theories to attack media activity, circumventing the protections of New York Times versus Sullivan and the like. So that's a bit of a summary of why I feel so privileged to get to practice in this area, and particularly privileged to practice with my friend David. So David, I'd like to begin, why don't we get into something really pressing, and this is something that was asked by the questions that Dean Minow sent.
First, could I just say something before we do this?
Sure.
Is that I've talked to this man 6, 8, 10 times a week for 11 years. We've never discussed one of those things okay?
That's true.
Not
yeah.
one, okay? There was a tour de force of legal mumbo jumbo, and I'm sure you guys understood it. But when I call him, I say, Fritz, are we screwed? Or, how do we get out of this? Or, can we get away with this? Or, what the hell am I supposed to do now? And so I didn't want you to think that we're having some kind of Aristotelian discussion every minute. It's basically, how do I stay out of jail? How do I keep my publisher from being sued? How do I walk down the street and still hold my head up high after I've committed some heinous crime against somebody's dignity? So I love that stuff, Fritz, but
Thanks.
We never talk about it.
All right.
All right.
So
Just
here's something
want you to know.
Here's something we do talk about. So David, if Edward Snowden had arrived on your doorstep with his flash drive of documents, what would you have done?
I'd have called you, 419. Now you think that's like some kind of joke to get out of this, but the whole point of this exercise, and Fritz and my coming here, is to tell you how we work and how we live in different worlds, and yet we live in the same world. And my impulse, and I think the impulse of many of my editor colleagues, is to lean on my lawyer. First of all, to find a lawyer whom you trust. I mean, to the extent to which you would trust your children with your lawyer. I have a sense, and this is much more important than New York Times versus Sullivan. I have a sense of trust in this man like no other relationship I have except with my wife. Certainly not with my kids. And I know that I'm going to get honest, fair-minded, and most of all, quick advice from him that I can live with. And sometimes I call him at 10:30 at night, like I did this week. This week I called. I know you have a whole thing ready to think, but I just want to tell you guys this. At 10:30, we had a story this week about the mayor of Pittsburgh. And this, watch what I do now. Am I allowed to discuss this? Sure. Okay. He just earned his retainer, right? So that I'll do that. Am I allowed to do this? So he believes in being a mayor, but isn't a fanatic about it, in that he hardly shows up at anything, unless it's a golf tournament or a baseball game. And so he tweeted some kind of stuff about how he was so proud to be at this meeting of his top advisors planning the renaissance of a great city and all this kind of stuff. And without realizing that tweets have geo, whatever they are, so you can figure out where he was, and he was at a country club when he sent this. Or at his house, one of the two, I forget which one, because there were two tweets. And I didn't think much of the story, not that I didn't think much of it, I didn't think much about it. I thought much of it. And I asked for some reason around 10:30 to have the story sent to me at home. And I read it, and I got, how do you say it in English, spilkies about it. I got nervous. And I was worried about the following things. Is it possible somebody could have hacked into something? I don't know much about this world. Could have hacked into something and made him look like he was someplace when he wasn't. How do we know it was him, etc. So immediately I just pushed speed dial on my cell phone and called Fritz at 10:30. And you did what?
Asked you several questions.
Right.
About where we got the kind of questions that you would think would be relevant. Where did we get the information? What have we done to verify it? Whom have we contacted to talk about it, and the like. And then what did we talk about after that, David?
I said, is it okay to go ahead? And he said, yeah, and we did.
Right.
Mostly, the intercourse that we have mostly consists upon my looking for him to say yes.
Right. And my
I'm like a kid, okay? I'm asking Dad.
You want permission.
I want permission.
Yeah.
I want cover also.
Yeah. And this is, contrary to that axiom, it's easier to do it and ask forgiveness than to ask permission ahead of time. It really doesn't work that way in the work we do.
But often, Fritz, we go back to stuff that we didn't even think anything
Right.
about. What was that thing with those two women? And remember that thing that we're involved? Are we allowed to discuss that one?
I don't know. I can't think what you're referring to.
We wrote a story about 8 or 9 years ago. It's
Sure.
This is a really good.
This is an interesting question.
Yeah.
I'd love to know what you all think about this. We're going to get to that in a minute, but I want to put a little bit of what David said back into the context of legal mumbo jumbo, which is my specialty. There are three things that we have to think about.
I said that with affection, not with derision, by the way.
There are three things that we have to think about when we think about, can the newspaper get in trouble for what we're doing? One is, are we going to harm somebody's reputation? The law of defamation gives remedies to individuals who have been the subject of false and defamatory publication. Falsity is a necessary element. In common law, interestingly, falsity was presumed on any defamatory publication. It was the burden of the publisher to prove truth, but the Supreme Court has ruled that that's flip-flopped under the First Amendment. So the plaintiff has the burden of proving falsity and also injury to reputation. And there are, as I'm sure you know, if you've studied New York Times or Sullivan now, all sorts of restrictions on that we may get into. But the first thing that we think about is this going to harm somebody's reputation? If the answer to that is no, then there's no concern. And then if the answer is yes, then you have to focus on the truth of it. And in certain circumstances on the subjective state of mind of the reporters. So we think about, is it defamatory? So here we have to think about, is this going to portray the mayor in a false and defamatory light? So we have to think about that, and then that gets into determining the accuracy of the information. Something that didn't really matter with the mayor, although he tries to separate his public and civic life from his private life, is the rights of privacy. For the most part, in American jurisdictions, public officials have forfeited any rights of privacy, at least in their current activities. There's still some support for the idea that stuff that political figures did before they became public figures still has at least a patina of privacy around it, but that wasn't an issue here. And then the third thing, as I alluded to, is this emerging set of torts that are called news-gathering torts, which aren't publication torts. They're not an effort to try to punish a publisher for what they've published. but rather punish them for wrongdoing in the gathering of information. And so we often talk through those in layers and be satisfied.
And sometimes Fritz says, that's not a legal decision, that's a journalistic decision, and which means bombs away. But journalistically, I don't want you to think that we're out to defame people and get away with it. I worry a lot, and I worry out loud in the newsroom about what I call the conflicting fairnesses. That above all, we try to be fair, but sometimes there are more than one sense of fairness. There's a fairness to the person you're writing about, and then there's a fairness to the reader. And there are occasions, many of them, in which the fairness to the reader is in direct conflict with the fairness to the person or institution you're writing about. And that's where it gets difficult. But we're worrying about, on my side, we're worrying about other kinds of things, and I want to assure you that it's value-driven and value-laden, that we are worried about fairness overall. And so it's not only legal, but it's also moral.
There's an organization that passes itself off as a news organization that lives with the motto of fair and balanced. Do fairness and balance mean the same thing, David?
No, in fact, fairness and balance almost always, or often, are in conflict, I think. I learned this as a very young reporter at the New York Times. I was about 27 in the Washington Bureau of the New York Times, and we had at the time some kind of a rubric in which you should pro or con on raising the minimum wage, or approving arms sales to Saudi Arabia, or such. And I would write these, what's for and what's against, and what the prospects was. And I began to get very queasy and uneasy about it. And then I realized that this form itself was a trap. And like, for example, what are the pros and cons of the Holocaust? For example, being fair and balanced. I mean, we're having a huge discussion now. It's prompted by a pressure from the left, but it could just as easily be pressure from the right. It comes in two dimensions from the left, though, I would say right now. Is a news report that gives equal balance to the argument that Obama is an intransigent as to the argument that the Republican rebels in the House are intransigents, is that a false balance that perverts the truth? Now, we can discuss this endlessly, but here's another one that's, I think you probably thought about yourselves. Is how much balance ought you to give to people who believe that there is global warming versus those who don't, and then people who believe that global warming is produced by human activity and those who do not? And at what point do you abandon balance? How much balance do you give to the Earth is flat versus the Earth? I'm reducing this to absurdity, but the principle is the same. Is the Earth flat? Is the Earth right? I mean, should we do a pro and con on that? So fair and balanced, that's balanced, but it's not fair. And that's the fairness to the reader that I worry about overall.
What is your obligation to a reader?
To as closely as, see, now he's getting prosecutorial on me. I usually ask him this question. The obligation to the reader is within the constraints of our art form, and I'm acknowledging that it has constraints, to present as honest and true a portrait of the world or whatever it is we're describing as is humanly possible. Now, I understand that there are constraints on all of that, but generally speaking, that's what it is. And that brings up another conflict that I worry about on my side that I don't think Fritz worries about as much on his side. Not to say that he doesn't worry about it, but it's more my worry than his in this relationship. And that is the difference between the facts and the truth. Because I think it is very easy And we had an example in the paper last week where I called a reporter and said to her, everything you have in this story is a fact, but the complete assemblage of these facts does not present anything that even remotely resembles the truth about this story, and I wish I remember what it was. But it's possible to list 7 or 8 facts that themselves give a portrait of something or someone which does not really represent the truth. I wish I had an example, I can't remember what it was.
What's an example when you said no? When you said David wants to do something, you say no. You can't.
Oh, it was this week we did about naming the guy who had porn on his, who had alleged to have porn on his machine in a fancy, in the equivalent of BB&N.
We had it's an interesting question. I think there's several we can talk about. You know, this one was a situation where a very highbrow Tony private school in suburban Pittsburgh had issued a press release announcing that it had terminated a longtime teacher at the school.
And named the teacher.
Right. That named the individual, said that the matter had been turned over to the FBI and the local Child Services Bureau for investigation, and then went on for some more details. So it's a really interesting question, at least it is in the part of the world where we work, because it had that. There are numerous privileges that publishers have for reporting on public records. That's why, for instance, you can safely print that somebody has been indicted. That's under what's called the fair report or the records privilege, and there's a long common law history of that, and it's also embodied, it's codified in almost every state in the United States. So you can print that, and you are not, as a newspaper, then subscribing to the idea that the individual is guilty. Under the republication doctrine, you are responsible as a publisher even if you're reprinting things other people have said, but this is an exception. But that doesn't apply here because this isn't a governmental press release, this is a private school. That was one of the things we talked about. Then you have to start thinking, okay, there's no privilege. What fair inferences could a reader draw from this? Because even if the facts are true, a publisher can be held responsible for defamatory implications if these are inferences that a reasonable reader would draw. So I'd ask you, if you were to read, a teacher has been terminated, the matter has been turned over to the U.S. Attorney and the Children's Services Board for investigation, the student's name is also deducible from the report, and it's hard to explain why, but except for the moment that a reader would know, if we printed the press release, the identity of the student whose matter had been turned over to the Children's Services Board. What inference would you as a reader draw from that report? Anyone? Right. Very good. It would be a fair inference to think, I get the criminal part of it. That could be embezzlement or who the hell knows what it could be. But if the matter is turned over to the Child Services Board, there's got to be some abuse, dependency, neglect aspect to this behavior. So then we have to start thinking, can we safely run it? It's true, but in this situation, it's not as though there's not enough truth in it. There's too much truth in this report. So we had a lengthy discussion with the Night editor and David about what we should do. Jamie, what would you advise a newspaper to do from the perspective of somebody who represents individuals? What would you think a fair thing for a newspaper to do on that?
Well, it's not my field, but if they sent out a press release that announced this, I suppose the fact of termination seems to me to be something that the newspaper could safely print. But obviously, as somebody who would potentially be representing an individual, I certainly wouldn't want a potential jury pool tainted with information that may end up being suppressed or otherwise never making it into a court of law. So
Right.
from a potential criminal defendant standpoint, obviously you want as little to be in the newspaper as possible. But
Right.
you know, that's a very that's a parochial interest. It's not the interest of the First Amendment. It's not the interest of the newspaper. I recognize that.
The analysis goes, the internal analysis goes deeper than what we've said. This is a relatively small example, but it's a nice window into the sorts of things that we have to think about when we're considering potential legal exposure. Assume for the moment there's no privacy aspect here, which there probably isn't, given that these facts are in a public news release. The sort of elements of the common law tort of invasion of privacy by publication of private facts probably wouldn't be provable. So let's leave aside privacy for the moment. On the defamation side, one of the things that you would look at, and this is sort of moving from the abstract level of the comments I made at the start to the concrete differences that arise from the holdings in New York Times versus Sullivan. The major revolution that New York Times versus Sullivan worked in the law of defamation is that it made initially public officials and now public figures have to face a much higher burden of proof and standard of proof than is true under common law defamation. As I'm sure you know, as a result of New York Times versus Sullivan and the aftermath of that, Curtis Publishing versus Butts and the like, public figures have to prove the mental element of actual malice. They have all the other elements of proving falsity and defamatory quality and lack of privilege and publicity to a third person, publication to a third person, but they also have to prove the mental element. Private figures have only to prove negligence. In other words, a deviation from the standard of care applicable to journalists. But public figures have to prove actual malice. It's a strange term that Brennan chose because it has nothing to do with malice in the sense of ill will or spite. It is the subjective state of mind of the publisher toward the truth of what was said. And later cases have defined knowledge of falsity or reckless disregard of truth to mean either a high degree of awareness of probable falsity or serious subjective doubt about truth. So it's something about the internal subjective state of mind of the publisher about the truth. So when we talk about this, I'll finish in just a second. When we talk about this makes a huge difference. Is this teacher a public figure or a private figure? If the person's a private figure and it turns out that whatever defamatory implication arises from the story is false, then the jury's going to be asked, in addition to all the other questions, was the publisher negligent? Well, assume for the moment that somebody in this chain of events had told our reporter, I wouldn't put too much weight behind that press release. There's a lot more to the story. If that comes out, and we published without knowing what more there was to the rest of the story, it's going to look pretty bad. That's not very careful. That's below probably what a jury would expect its reporters to do. But if this individual were to be deemed to be a public figure, then the test wouldn't be, did we depart from the standard of care, but did we, at the time of publication, did we know it was false or doubt its truth? Completely different inquiry. It's a subjective test. It's not an objective test. That structure has been savagely critiqued because it can be made to look like it's encouraging willful ignorance or willful blindness. Renata Adler, the great novelist who wrote in her book Reckless Disregard, truly a devastating critique of the concept of actual malice. But regardless, it remains the law. So we had roughly that discussion. This is not one of these highfalutin discussions. We actually talked this through. So then, David, what did you think about after we had this byplay about?
Well, I thought I was worried about our vulnerability given what we had been told in a sidebar conversation. Often, and from my point of view, I weigh the the marginal benefit to the public's knowledge versus the marginal harm. Now, this isn't a concept I got from you. This is one I have myself. The marginal harm to an individual, and which I try to weigh those two. In a completely separate case, which didn't involve you, Fritz, I probably should have called you. But some Sunday afternoon, I was tooling around with my wife, and I got a call on my cell phone that we had discovered that something about a police officer who had been cashiered in one way or the other, disciplined, and for his having abused his girlfriend, something like that. And the police chief wanted to talk to me right away. So that's not a call you wait until you get to the next Dairy Queen. You make that call right away. And the police chief said, okay, listen, you guys have a perfect right to write this. I'm not disputing this, but if you write this, he'll kill his girlfriend. So I didn't call you on this one. Maybe I should have. I instantly said to myself, okay, what is the marginal public advantage to know the identity of this person versus the marginal danger for the girlfriend? And in my mind, I don't think it was even a close call. The city of Pittsburgh is not substantially impoverished today because we did not publish the name of this officer. So I figured I was on a roll here, and so I said to the police chief, I'll make you a deal. You keep this man off the street, I'll keep his name out of the paper. How did I do on that?
Great, great.
All right.
Do you
I want to add one thing to something that that you can see that I know I'm not on. I know I'm on foreign territory. I'm asking him these questions all the time. I mean, one of the things I know you need to know is it, as lawyers, what are your clients going to be like? What are they going to ask? One of the things Fritz has mentioned recently was a departure from normal standards of conduct, and we're going to get into, I know in a few minutes, the celebrated, mega dangerous, amazing case we were involved in for months and months, and for which I was deposed for 16 hours. But one of the things I learned was, whatever you do, just do it the same way all the time. And do you want to talk a little bit about this, Fritz? Because, for example,
keep going.
This comes up in the context of, should a reporter keep his notes? Should a reporter do this? Should a reporter keep tapes of what he or she does? And Fritz's answer usually is something along the following: just do what you always do. Don't put yourself in a position to be vulnerable for a prosecutor. So, for somebody to ask you, how come in most cases you kept your notes, you keep your notes, but in this particular case in which mega millions are at stake, you just happen to throw yours away? Be able to be consistent.
One of the reasons that what David just mentioned is so important is that it's a very common pattern for plaintiffs in tort cases to try to set up some objective industry-wide standards for behavior. Now, this is how products liability cases get litigated all the time, and all sorts of other cases get litigated all the time, and I would imagine it's even relevant in suppression motions sometimes to try to demonstrate that the police handled a certain situation differently than they handled others. Certainly that was a big part of the defense of O.J. Simpson, to try and demonstrate that Furman and others acted differently toward O.J. Simpson from how they had acted with others. So it's a very familiar pattern when one is defending a case of this kind to see the plaintiff's lawyers try to get journalists to adopt some objective standard of behavior, whether it's the code of ethics promulgated by the Society of Professional Journalists or the Columbia Journalism School set of ethical constraints and the like. It's a very dangerous thing for libel defense lawyers to allow happen, however, because journalists, there's something about life experience that causes most journalists to be iconoclasts and skeptics and very prone toward idiosyncrasy and so forth.
Who, us?
And it's almost always the case that every journalist on a case acted differently toward whatever you're trying to answer. Did you tape record the interview? Well, yeah, I did this one, but my partner didn't tape record those interviews. Did you save your notes? How many drafts did you write? And so forth. Did you do interviews in groups or not? So one of the principles that we work on is stay away from rules and just behave as you always behave. If you behave by rule, then that's fine. But don't artificially adopt a rule, and certainly don't deviate from your past experience, because that's the sort of thing that even in an actual malice case, public figure case, can, under the holding in Connaughton, be introduced to the jury as evidence of a different attitude toward truth. Otherwise, they would never have destroyed their notes in life. Did you want to ask a question?
I'm going back to that school press release. You just have to think for a moment. It's not a public record. So anybody could get a megaphone for their libel by making it public, and then that becomes something that you could report, and having sent out a press release, all of a sudden immunizes what is clearly defamatory, because it was called a press release. It can't be right. And that's obviously why your instinct was what it was.
Yeah, I was worried about this. You know, there's another thing that we talk about a lot, and that is, I know this is kind of a abrupt change of subject here, but that is how the internet has changed a lot of this, and we're continually asked to change things on the internet. And we want to get to this case with this.
This is an interesting case,
with
yeah.
these women. I don't remember the specifics of it, but we wrote a story about some episode, and you probably remember what it was. And we changed our website, and like we do all the time, as we do all the time, and there was a glitch in the software, in the coding, and so rather than saying this, this appeared in the Post-Gazette on August 29th, 1998, it printed, it said, you know, September 1, 2013, or whatever. And then we got sued. Want to talk about that one?
Yeah, there's a little bit more to it. There was a story that the
He's going to say there's more to it, but really that's all there was to it. But go ahead.
Just a little clarity on what you said. We published a story, I think in 2005, about two women who were indicted for prostitution in a massage parlor, and about the process of plea bargaining that led them to plead guilty to solicitation, attempted solicitation of prostitution. And the story was immaculately true when it was published. And it rests in our digital archive and is retrievable by any number of methods online. The software functions by putting across the top of the page the date on which it is retrieved. This is very common. I'm sure you've seen this thousands of times. Across the top is the date of retrieval, and under the, either immediately under or immediately above the headline is the date of original publication. The software glitch David mentioned changed the date that was immediately above the headline from the date of original publication to the date of retrieval. So now you've got March 12, 2012, and a story that says, last month, person A and B were the victims of a police sting and were determined to have been involved in prostitution and were indicted, and they plead guilty. And you know, the prosecutor said that the defendants have agreed to plead and they will be sentenced next week. At the bottom of the story, the reason I wanted to say there's more to it, at the bottom of the story it still says originally published March 5, 2005 or whatever. The allegation of the complaint, for which we have some reason to doubt, is that these two people had applied for jobs, and in the job in the employment process, the prospective employer did a name search for these people, and our stories came up as though the last month was March of 2012 and they were going to be pleading guilty in 2012 when in fact it was 7 years ago. That's what happened. Do you think that's a valid suit? What do you think?
How many people think yes?
Yeah.
How many people think yes? How many people think no?
What?
How prominent was the original publication date on the bottom?
It's very prominent. You read down to the whole story, then there's a line, and in bold letters it says originally published, March, I think it was March 5, 2005. Now, that should have been also at the top, and it wasn't. So who thinks that the newspaper should be liable for that, for what is in effect a software glitch?
Well, I mean, I think people so infrequently read all the way to the bottom of the story, and I think that your understanding of when this was published is completely dependent upon that date that you see at the top. Mm-hmm. And so, I mean, if this did actually damage the reputation, then I think it would.
What do you think? And not only do people rarely read to the bottom of the story, but a journalist structures the story in particular to get all the important information out at the top. So I think there's some element there that makes it reasonable for someone to not necessarily even read all the way to the bottom and see that date.
You're referring to the journalistic convention of what's called the inverted pyramid, which probably has less currency in journalism now. It was a wire service convention for various editing rules.
I'm personally offended by the notion that not every word that we write is read, but go ahead.
I'm interested. You don't have to answer, and I certainly don't want this to feel like some Socratic moment we're having here, but I'm curious in your reaction to this. Another paper I represent had a years-long fight, which involved, among other things, this issue. The newspaper published a story based on some internal affairs files of a police department. And the overall series was, do the police do a good job of policing themselves? You know, going back to Socrates, who guards the guards? That was sort of the theory of this story. So we did a big story, like an 8-part series on this. One of the days was on neglect of duty. And we led the story with a very dramatic story, led that article with a very dramatic story about a domestic dispute, and the police had they arrived at this apartment because they'd been called there. They walk in, there's this dude curled up in the corner. The wife says, "Oh, don't worry, he's drunk," and he fell asleep. It turns out she had stabbed him. He was lying on top of a knife. Had the police even gone over and moved him, they would have discovered that. So we wrote this story, and before the carryover on page 1, we told the whole story and the determination by the police chief that had constituted neglect of duty. Then you get to the bottom of the column, you know, look for neglect on page A6, you turn to A6. That finding was reversed on appeal through the Civil Service Commission. One of the theories in that case was supported by Columbia analysis. You know, I don't remember the number, 72.8% of people who read a story don't turn the page. So their theory was 72.8% of the people who read the story are left with a false impression, not only about the facts, but that their supervisor had determined they committed neglect of duty, and only 20, whatever it was, whatever I just said, 27.3 or whatever, would have learned the truth. Based on what you said, is that a valid theory?
I would say maybe not in that case, because the understanding of the telling of a story and the events that play out throughout the story is that you think that it's possible that things that happen later in the story may change your understanding of what was said earlier in the story, but your understanding isn't that the date of publication is going to change as you read through the story. So I think that it's fundamentally different.
All of which is why I will often, I would say 4 or 5 times a month, say, hey, this story looks okay, I want Fritz to see it. So one of the main things he does is pre-publication review. And that isn't only of the story, but it's of the headline and often what the page looks like, how prominent it is on the page, where it's played on the page, the nature of the by the nature of the headline, I mean whether it's bold or italics and this kind of stuff, and that we will often send the front page or whatever page it is to Fritz, and he'll sometimes fiddle with it.
I'm mindful of time. Do you want to ask people to ask questions?
Any questions? Yes, ma'am.
I want to go back to the conversation about sort of the relative fairness. I lived in Pittsburgh for a year, and I had the pleasure of reading all of your wonderful articles about the mayor.
All the way to the end, right? I don't mean to lead the witness, but.
Especially recently when he was supposed to step down and decided not to. But I guess my question when it comes to fairness, is it fair to the mayor that he kept publishing those articles, although his perception was so bad?
Is it fair to the mayor that we publish the articles even though what now? I'm sorry.
Even though the reader wouldn't benefit as much, because I felt like in Pittsburgh, the perception of the mayor was already horrible.
So in other words, let's take it apart from the mayor so you can protect me on this. So I'm not talking about the mayor, but say someone is such a known scumbag, okay? Am I safe so far?
Sure.
All right. That no amount of more scumbaggery is going to further diminish his already pitiful status in the community. How would we put the paper out if that were the case? I mean, you'd never be able to write a second story about Ty Cobb. You'd have a hard time writing another story about Richard Nixon. You'd have don't put us out of business with this.
If you could talk about it, can you talk about experience of when you, Mr. Shribman, went against your advice and went ahead with the story, and why did you do that?
There has not been a case, and there won't be a case, because this is a relationship of tissue of trust that's immutable.
Would you ever argue back?
Yeah, sometimes.
Oh, yeah.
Oh, remember that time? Remember that time late at night? It also involved the mayor. Involved the mayor and a security detail.
Right.
And we wanted to say such and such, and he was playing the prig on this one. No, you can't do it. And I was really getting nervous. I was out prigging him, saying, oh, maybe we shouldn't do this at all. And then we went back and forth for a long time, and we were at deadline. We held the paper while these two idiots had this Socratic conversation. Right. I mean, it cost money.
I remember one time, Dean Minow, where we actually held start date on the front page till 1:30 in the morning because we kept going, and sometimes these judgments are very, very tough. The journalistic judgments are agonizing, and although you'd like to believe that the legal regime is clear, we know better than that. So yeah.
Well, I mean, my feeling and why my answer was no, I really have never contradicted him, is because I'm going to need him later. No, I mean, I don't want to go into court naked. I need to know that what I'm doing is. I mean, you're probably saying, well, this clown here, who's the editor of the paper, he doesn't know anything. He's always asking this other guy's advice. But I know what I want to do and what my responsibility is and what my inclination is. But I don't want to be ruled by my inclination. You wouldn't want to be in a dating relationship where someone was ruled by his inclination rather than by his morals or better judgment. You wouldn't want to be involved in any relationship whatsoever in which you didn't have a check and kind of the good conscience sitting on your shoulder. Go ahead.
If I may say one thing before you, on the point of accepting or disregarding advice, I have had clients reject my advice, although in the end I don't give orders, I just say here are the risks and so forth. But I will tell you an interesting experience I had with a paper. It wasn't David's paper, but a different paper I represent, that rejected my advice about one word in a headline. It was a story about alleged police brutality, and I'm not going to go into the details, but I recommended against using a particular word in a headline, and the newspaper went ahead at the insistence of one of the reporters and used the word. A lawsuit was filed. There were dozens of claims in that lawsuit, but one of them was over that word. And it raises a very intricate problem for a lawyer in that situation, because one of the defenses in actual malice cases is advice of counsel. I did it because my lawyer told me it would be fine. So we had to think a lot about, do we want to use the advice of counsel defense, which then would make me a witness, and I wouldn't be able to defend the paper. I'd be a witness in the trial, and it would open up all the communications on that article. This was an 8-day series. So it was a very intricate decision. We ended up not raising the advice of counsel defense and relied on a couple other doctrines that we believed would protect us. And in the end, we got summary judgment in that case. But it was I thought I'd mention that to you because it's sort of a nuance of advice of counsel and what would be the possible consequence of disregarding it. So.
You know, I have something I say in the news, and I must say this 5 times a week. If you have a good lawyer, what kind of an idiot doesn't listen to him? Okay? I mean, if you change your lawyer, but stick with the advice of the lawyer you have today. We don't pay him all that much, but enough. And we paid this person good money for his advice. Shut up and listen to him.
Yeah.
During the lives of most of the people in this room, the presidents of the United States, all of them, and their attorneys general have condoned the murder and abuse of innocent American citizens by condoning the FBI informant program, under which informants are allowed to commit horrific crimes as long as they're allegedly informing and cooperating with the FBI. There was a spectacular demonstration of that this summer in Boston at
You want to ask a question? Ask a question. We just
at the Whitey Bulger case.
Right, yeah.
But no one saw it except the people who attended, because John Roberts won't allow cameras in the courtroom. My question is, why is it that academe, the media, and the legal profession does not get together and with a campaign, both in the courts and in the legislatures, to not defer to John Roberts and force him to just blow up in smoke by a campaign to get cameras into the courtroom and expose the misconduct, the grotesque misconduct that has corrupted the Justice Department for 40 years.
I'll answer the part of it that I know something about, which I know you think is uncharacteristic, Fritz, of me. But nonetheless, I have some experience with this question, having covered the Senate for almost 2 decades. And my bottom line is that I always want more openness than less. That I believe that sunshine's a disinfectant, to use the old phrase, and that I prefer things be open. And yet, the moment the Senate was opened to television cameras, Al Gore became a fixture on television in a grotesque way, in which he basically, and he and others, basically changed the entire rhythm of the Senate as they grandstanded in front of the Senate. Now, was the public served by that? Probably. But as an individual here, not as a journalist, I'm weighing the tradition and the prerogative we in the pencil press used to have of having exclusive rights versus the other thing. So I actually think there should be cameras in the judiciary. I think cameras have a distorting effect on things, but that overall it's a good idea. I wish we had it. We have so few open proceedings in the Commonwealth of Pennsylvania that it's horrifying. But I do want to say that I'm temperamentally a romantic and a traditionalist, and the days in which the House and Senate, in which we could go in there and record what was happening, the TV guys couldn't, I have to admit, I liked more than I should.
Jamie, as somebody who's has handled and is currently handling a very high visibility criminal case, what are your thoughts about cameras in the courtroom? And have you had the experience David just described of seeing it distort the behavior in the courtroom?
I think probably not as much as in the political arena, because the people in the courtroom are not running for anything, hopefully.
They're running from something.
Yeah, some of them are. But I don't have in Massachusetts, the state court proceedings are all now televised or can be televised. They're open to the media. And I don't really have a problem with that. It's a little odd that, as the gentleman said, that federal court proceedings are still not open to be televised. And I don't think the world will come to an end if that was permitted at all. I think that the distorting things are things that happen outside the courtroom. So I don't have a problem with courtroom proceedings being televised at all levels.
Mm-hmm. I'm a journalist myself and have had many conversations with lawyers pre-publication, and I'm wondering, when you give advice, and when you take advice, what level of risk are you factoring in? Are you trying to advise against a lawsuit? Because I've had many of our lawyers try to do that. Or are you trying to advise against losing a lawsuit?
Well, I want to answer that, and Fritz, I don't mind the lawsuit. First of all, it's an employment program for him. I just don't want to lose it. And sometimes we won't do stuff because we know we'll lose, and the act of losing will further endanger our other privileges. You want to talk about that?
Right. I'll answer your question and then comment a little more expansively on what David said. I define my job as finding a way for my clients to put into print or out over the airwaves anything that they want. I don't remember ever exercising sort of the final veto. I know you want to do it. I'm not going to help you do this. I don't think I've ever said that because that's not my job. The two papers for whom I do the most work are run by the same individual, and he believes the old adage that you go with what you know. If you know the information, I mean, provided it meets the other tests, it's true, and lawfully obtained, just print it. So that's my job, and I think that's in the service of the media organizations I represent. It's a cliche to say it, but like many cliches, a fundamentally true one, that anyone with a pencil and a filing fee can file a lawsuit. If one were to be deterred by the prospect of a lawsuit, we would all just be in the business of printing press releases. And fortunately, the publishers I work for uniformly aren't in the business of just printing press releases. My job is to minimize the risk of printing information that David tells me he wants to, based on his news judgment and other journalistic judgments, wants to put in print. So I hope that at least addresses, I know it's not a scientifically precise answer, but my job is to minimize the risk, and you do that by any number of ways. Some of the ways you do that are by ensuring that the rudiments of good journalism have been followed, that we've been responsible and diligent and are taking quotes, trying to tell the truth as we know it and give comment where comment is appropriate. Being familiar with how the legal privileges that apply, whether it's fair report or fair comment or neutral report, how those privileges would apply, maybe changing the emphasis or the structure of the lead or making sure there are adequate attributions so it's not, say, the Post-Gazette is saying that this defense contractor short-circuited procedures, but an internal report of the defense contractor saying that allows you to take advantage of fair report and so forth.
But sometimes Fritz will say, okay, you're probably going to get sued on this. And we'll say, well, so be it.
It's just, it's the way it goes. And I said at the start that these principles and the values that, from whichever perspective we come to these issues, these principles are under a tremendous amount of pressure, and the first kinds of pressures I identified are economic pressures.
We spend an enormous amount of money, he hasn't built a swimming pool and bought a yacht on all this, but we spend an enormous amount of money on legal fees, trying to open up proceedings that are closed. Right. And I'm constantly being asked by our comptroller, do we have to do this? Do we have to sue them for that? Do you have to sue something when you know you're going to lose? Really?
These are affirmative actions trying to open up proceedings.
Was it all that important to you to find out this? Really, couldn't you live without this? And I feel that not to, and we're talking about something different now. These are us doing the suing, or us doing the, I don't know if suing is the word, the initiating.
Yeah, initiating the
Yeah.
actions.
And, you know, do you have to, oh, come on, we lost $22 million this year. Do you really have to, is it all that important to find out what happened?
Will it really sell another ad if
I
we
mean,
put
really,
this
come on.
on?
And I say,
And
you
there's
know,
no answer to that
and
question.
sometimes I say not to do this is to itself be, is to accede to this policy that we can't do this, and if we don't do this, we're complicit.
And one more comment, if I might, on that. On the defense of defamation suits, our insurance premiums are relatively high because these papers get sued relatively often because we're very aggressive. And I can tell you, I've represented these papers for about 25 years. We have never settled a defamation case because we believe there's never been a meritorious one filed against us, and we've never lost one. But there's a lot of expense. The lawyer's expense, the insurance expense, a hidden cost that is significant is the drain on David and his staff for depositions and time with me and just reviewing and record collection. You know, we had this large suit that I thought we'd actually spend a lot of time talking about, and we haven't. That a huge corporation sued the Post-Gazette, and the production filled, you won't believe this, the document production filled 29 bankers' boxes. Just a tremendous amount of work, but
It was $8 or $9 million altogether.
What was that suit? And what happened?
this was I can't talk about the details, but I can tell you what it structurally was. The Post-Gazette received information, and it has a lot of really interesting elements in it. Information from a confidential source that there was an internal investigation at a manufacturing plant regarding allegations that had been made by internal whistleblowers that the manufacturing plant had deliberately short-circuited procedures that are required by federal regulation in a heavily regulated industry.
And its own procedures as well.
And its own procedures. So we have a confidential source there. Then the internal report arrived in our mailbox, and circumstantially it was clear that it had been taken by somebody. Was that me? Oh, okay, sorry. Okay, sorry folks. The report made it clear that the copy we had been taken by somebody who was not authorized to give it to us, so you could say it involved stolen property. It involved a very serious allegation of wrongdoing, circumventing federal regulations. The potential implication from the story, even if the story said, according to a report, that this manufacturer had put onto the market really dangerous instrumentalities.
There involved two other questions too. One was malice, whether we had, am I allowed to say this?
I don't know what you're going to say.
Whether we had a predisposition against this company.
Right, yes.
And
right.
the other thing was, did the thoroughly unremarkable act of a journalist giving an institution a chance to reply, and their not having replied, did that give us license to publish a story? Now, we think that's an unremarkable thing. I mean, you guys are all too young for Watergate, but basically the entire Watergate thing was structured by, we find out something, we call up the Nixon administration, they say it's not true, we print one graph that says the Nixon administration denied it vehemently, go on and write the rest of the story. And that's a thoroughly unremarkable part of journalism that became under fundamental attack in this. And it was one of the major opinions, and it's something that I had never given more than 4 seconds of thought to. And yet it was maybe the linchpin of this whole case.
The plaintiffs spent literally millions, I'm not going to tell you how many millions, but many millions of dollars on 8 lawyers who worked on this case full-time for 2.5 years. And they opened, I mean, if we could go through the details, you would, I mean, every word in the story was challenged. For instance, the difference between Acme Corporation was not available to comment, declined to comment, refused to comment. Why did we say refused? There's an entry in the style book that purports to tell reporters how to write that sentence in a story. And what's in the style book didn't match what ended up in the story. So David, as he said earlier, was deposed for 16 hours in this case, probably for an hour on that sentence. Why did you let this into print? Did you choose the word refused to besmirch the corporation? Why didn't you say was not available? Because, in fact,
They were available.
they were available, but they never got back to us. So they didn't say, their argument was, we didn't refuse. We didn't say, hell no, we're not going to comment. We just never returned your calls, although you tried for 4 days to reach us. So,
And also in that thing was, what is a reasonable amount of time
right.
to respond that we should allow the other party to respond? Now, my answer to that was, it was your report. You know more about it than we do. You should be able to respond immediately.
Right.
Is that case still pending, or is it settled?
It's fully resolved. Yeah.
We don't use that word.
We got a very satisfactory resolution. I don't mean to be coy, but there is a settlement agreement in this case, and it imposes certain limitations about talking, but we're very satisfied with the result. And I can tell you unequivocally that the Post-Gazette did not pay a single dime, and it did not retract the story. So you can make your own conclusion from that.
So you printed the story?
Oh yeah,
Oh, yeah.
The story ran, yeah. And then there were lawsuits over what we call news gathering lawsuits, trying to attack how we got the story. What wonderful. Possession of chattel, or what trespass on the chattel, that was one of the claims. I'd never had a trespass on the chattel case.
And
I don't think I'd ever used the word chattel since I left this place.
We're technically done 15 minutes ago, and so you can walk out with impunity, or with immunity, as you would say. But we're happy to sit here for a little longer. Wait for
So let's first thank you very much.
Thank you.